Hiteshi, you can start.
So, good evening to one and all present here. It is my pleasure to welcome you to today's online lecture on artificial intelligence and copyright infringement. We are pleased to welcome our guest lecturer today, Mr. Ankit Shrivastava, Assistant Professor at Symbiosis Law School, Noida. Without any further delay, I request you, sir, to kindly proceed with the session.
Thank you so much, Hitashi, and thank you so much, Ms. Vartika, for giving me this opportunity to interact with the students of NUSRL Ranchi. So I'd be basically cutting short the introduction and would be just straight away starting with our topic today, that is artificial intelligence and copyright infringement. So, artificial intelligence, especially, is a hot topic now. It is something which is affecting our lives. It is something which has already started to make its way into our daily life. Even when we are not aware of it, there are a lot of things which we do, which is directly or indirectly in which artificial intelligence is involved. For example, a lot of students in the legal fraternity, they do use chat gpt. There are a lot of questions of plagiarism. There are a lot of questions of copyright infringement which is taken up. But what happens with respect to intellectual property rights infringement and how to deal with it is a very much of a gray area. There are a lot of concerns related with artificial intelligence, related with intellectual property, which is as of now completely unredressed. So there are going to be a lot of open questions even after this talk. But there, I hope this particular talk brings some clarity with respect to the issues which are there in the present IP law regime with respect to artificial intelligence, and what are some of the suggestions which the legal fraternity has looked into as of now. So I'd also be taking help of a PPT. Just give me a moment. Just give me a moment. I'm a little new to SteamYard. I've not used it much. Just I'm not sure if you can see the PPTs. If someone can please confirm if the presentation is visible to you.
We can't see the presentation yet.
Okay, just give me a moment. Yeah, I hope it's visible to you now.
We can't see the slides yet, sir. Okay, it is loading. It's loading.
It's loading. Okay.
Yeah, we can see it now.
You can see it. Right.
Yeah.
So, before getting into the various subtopics which I'd like to cover today, that is understanding of artificial intelligence, intersection of AI and IPR, copyright protection of for AI creation, and ethical and policy considerations, I'd like to first start with understanding of artificial intelligence. So, see, artificial intelligence, even though it is something which has been in news, which has been all over since the past 3 4 years maximum, it's not that it's something new. It has already been taken into picture. It was already in the development since as early as 1950s and 1960s. The problem with respect to artificial intelligence at that point of time was it was not having the kind of capacity where it could match human intelligence, and as a result of which, whatever results the artificial intelligence used to be in a way either subpar with the human intelligence, or even if it was not subpar with human intelligence, it was better than what human intelligence was capable of. It still needed a lot of human intelligence intervention. So either you can use artificial intelligence with subpar results, or you already need certain kind of human intelligence in order to operate those artificial intelligence. Since coming up of generative AI, where the artificial intelligence it started to take up the role of human intelligence. For example, I'm sure a lot of you use Zomato, a lot of you use Amazon, you use Flipkart, etc. And you must notice that in the past 3 4 years there has been a change. Earlier, when you used to contact the customer care service, either you had an option to call them up, or you had an option to chat with them. Now, when you go to any kind of customer care service, there is an option of chatting with the AI of that particular thing. So they've named their AIs differently, but what it actually does is that it has some kind of capability where it can mimic the human cognitive functions, and as a result of which it can understand your problem, provide you a resolution, and without any kind of human intervention, your problems can be solved with some kind of basic resolution which the people are going to anyway give to you. For example, if you're using Zomato and your delivery is late, the artificial intelligence knows that what is the resolution which is usually provided by them. They would be offering you 50 rupees of coupon code, so you don't need a human intelligence to tackle that. If the customer is satisfied with that kind of solution, which even AI can basically provide for, then there is actually no need for human intervention in that. That is how artificial intelligence has taken over a lot of human uh, 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 cognitive functions, and as a result of which they are able to replace human intelligence in a lot of sectors. So, what is artificial intelligence? So, with respect to this example, we can understand that artificial intelligence is something which is having various technologies and methodologies which are aimed at creating systems capable of performing tasks that typically require human intelligence. Now, this is a very basic definition of artificial intelligence. So basically anything which is generally considered as something which is related to human intelligence. We don't call a calculator artificial intelligence. We don't call a computer artificial intelligence, because in all these machines, what is required is that we do input certain things directly, and only on basis of the inputs which you have given, only on basis of the instructions which you have given, it is going to give us a result. When it comes to artificial intelligence, it has also been able to mimic human cognitive functions such as learning and problem solving. When it comes to ChatGPT, for example, you don't actually give it all the inputs. You don't tell it everything. There are certain things which it is able to perform on its own. It's not going to ask you for each and every input. For example, if you ask the ChatGPT to create a script for, let's say, Independence Day of India, it is going to derive all the information from the internet. It is going to derive a lot of information which is going to be vital for that particular speech. It is going to add some kind of slogans also in it, and it will give you a good patriotic speech. In this, you're not entering each and everything. For example, you don't have to enter the date of independence. You don't have to enter what are the various things which you need in that. If you add such kind of information, it can give you better results. But these are certain things which the artificial intelligence, that is the generative AI of ChatGPT, is in itself capable of deriving out of different kind of internet sources. So the science and engineering of making intelligent machines, especially intelligent computer programs, is known as artificial intelligence, which refers to systems or technologies that mimic human cognitive functions such as learning and problem solving. Now there are different kind of AI systems. Like I told you, it's not something new. So we can broadly categorize artificial intelligence into two systems. One is narrow AI, which is also known as weak AI, which is designed and trained for a very specific task or narrow set of tasks. For example, the earlier iterations of artificial intelligence, for example, Siri, uh, Alexa, Google Assistant, all these things have been in picture for a very long period of time. And you know that all these personal assistants which I named, I can't take their name again and again because a lot of my devices they turned on when I took the names of these personal assistants. So a lot of these personal assistants, they are going to be, be used, they are going to be understanding only some set of instructions. When you first use start using this personal assistant, you get to see there are a lot of instructions which it can understand. You would be slowly and gradually understanding, okay, this takes this instruction also, this takes this instruction also. Also, for example, you can ask these personal assistant to play a particular music from a particular singer or a particular music composer, and it was going to sing you for that. But it cannot create something which is beyond its training, something which is not specified to it. For example, the makers of these personal assistants have given them certain prompts. If somebody says this, you need to do this, so that is a very specific task which is doing. It is obviously, there is some amount of artificial intelligence also, because it does not expect you to give a very specific command which was required for the earlier programming languages. For example, anyone who has studied computer science would know, for a programming language, for example C++, you need to type, you need to specifically provide for certain instructions. Even if those instructions are going haywire by even one single spelling, or because of one punctuation, it's not going to give you results. Now these weak AIs, they don't need you for that. It can basically deviate a little, but it still be able to understand what is being required out of it. With respect to general AI, which also is referred as strong artificial intelligence or artificial general intelligence, it is a hypothetical AI system with generalized human like cognitive abilities. This system would possess the capacity to understand. It keeps on learning, and that is why you see all these artificial intelligence that will keep on getting better and better as and when we are training them. And how they're getting trained? By different experiment experiences, by understanding and applying the knowledge which is across a wide range of tasks and domains which are similar to human intelligence. For example, if I give a task to a human being, that human being would do that task for the first time on basis of the understanding which has got. The next time it is going to do that task, it is going to use its own experiences in the first time as well. And as and when the experiences would be increasing, this person would be able to give better and better results. Similarly, with general AI, it is also understanding a lot of things. It is using a lot of capabilities and giving you good results. There was a launch of new Pixel devices, the Google Pixel devices, in the last week, and it showed that how can you can click a picture, and the AI will understand that you want a picture of a group. So as a result of which, the person who clicked the pictures initially can come, he can exchange the camera with the person who was in the picture at that point of time, and then this person can stand there, and there can be a group picture in the end of it. It would be compiling all that pictures, which is a work of a generative AI, because it is able to process all the information. It is able to understand what is needed to be deleted. Similarly, with respect to the delete feature in a Pixel devices or in some of the Samsung devices, where you can delete certain things, it is not asking you to demarcate actually like how people used to do it in Photoshop. Now you just have to click on it. It will be applying its knowledge, it will be applying its understanding, its training, and it will be deleting that part which it thinks that the user intended to delete. Now, application of artificial intelligence because of this weak AI and now the strong AI has gone into specific fields. For example, healthcare. Now there are a lot of robotic surgeries. Now into finance, where people are now starting to predict how the stock market is going to function, depending upon different factors. It is not just that it is going to give you a straight line so as to understand the curve, but it is also going to factor in a lot of external information which is available in the internet in order to predict certain things. Transportation. You must have heard about those automated vehicles where the vehicle is being not driven by a person but it is being driven by AI. So there are different artificial intelligence related uses which are there now actually in practice. Whereas 4 5 years back it was just in talks, but you can see in these half a decade only there has been a lot of artificial intelligence which you can actually see in practice, in practicality, being used in a lot of ways, including your favorite chat gpt. So ChatGPT is something which is known as a generative AI, and that is one of the things which has challenged the basically the domain of intellectual property rights the most. How we're going to be discussing. Before that, let's very basic for the interest of people, for the interest of students who might be in their initial years who are not aware about what is intellectual property rights. Intellectual property rights. You can divide this particular term into three words, like it is apparent: intellectual, property, and rights. Intellectual is something which is creation of the mind. So, intellectual property means creation of the mind, such as inventions, literary work, artistic works, design, symbols, names, because these are not properties which are there in tangible forms. These are intellectual properties, hence they are creation of mind, they are in intangible forms. When we're talking about symbols, we're talking about designs. Yes, you can feel it, you can touch it, that is there, can be, it can be there in the tangible form as well, but you're not claiming that tangible form as the property. You're claiming the design of it, you're claiming the symbol of it as the property in the intellectual sense, that is the creation of your mind. For example, if there is a logo of a brand like Nike, you're talking about when I say about Nike's trademark, that take picture which is officially known as the swoosh, it will come to your mind. Now that swoosh is something which has been created after a lot of consideration, after a lot of market studies, what kind of uh, picture would look good on the shoes, it would also look good on other sporting accessories, it should have an appeal, it should have some kind of distinctiveness. After all that thing, they have zeroed on that particular thing. So it's not that physical swoosh which we are talking about, that physical logo which we're talking about, we're talking about the design of it. Its distinctiveness is something which has been created through the application of mind. So these artistic works, designs, symbols, names, and images, they are used in commerce, and as a result of which there are certain exclusive rights which are enjoyed by the makers or the authors of these intellectual properties. Those exclusive rights are known as the intellectual property rights. The rights, the exclusive rights which one can enjoy over the intellectual property is known as intellectual property rights, which are the legal rights that protect these creations, granting exclusive rights to their creators or owners. Now, in this lecture, because the ambit of the intersection of AI and IPR is huge, we can talk about AI and I and patent, we can talk about AI and trademark, but we are going to be restricting today's discussion only upon copyright. So copyrights, they protect original works of authorship fixed in a tangible medium such as literary, artistic, musical and dramatic works, as well as computer software and architectural design. So these are certain things which are having some kind of authorship, they are having some kind of protection over creations which are, in short, if I have to categorize all these things under a single umbrella term, I would say copyrights, they protect certain kind of creative works. All these things are creative works, whether it be literary work, artistic work, musical work, dramatic work. So these are different kind of creative expressions. So when they are creative expressions are basically uh, narrowed down into some kind of tangible medium, when you are expressing it in some kind of tangible medium, what you're expressing, your creative inputs, your creations of your mind into some kind of tangible medium, that is something which becomes the subject matter of copyright, such as literary work, for example, whatever you have written, artistic work, any kind of sculpture or anything which has expression of your artistic creations, any kind of musical tunes that can be protected as musical work, dramatic work, that is any kind of drama or a play which has been given a form of a script, as well as computer software and architecture designs. Now, the copyright is it grants the creator exclusive rights to produce, distribute, perform, display, and create derivative works based on the original work. Copyright protection, it arises automatically upon creation and registration is not required, although it provides additional benefits. For example, if there is anything which you have created, an original musical work, that point you publish it for the general public. For example, you are publishing it on YouTube, let's say. Uh, the moment it reaches the public, it is your work. You don't need to register it. It provides additional benefits. What kind of additional benefits? The additional benefits can be like you don't need to prove it in a court of law at that when there is any kind of question of infringement. So you don't have to start with establishing that it is your copyrightable work. If you have not registered it, you'll have to initially prove with the help of evidences that this is a work which is your work, you are the actual owner of that work, and hence the person who has used it without your permission has exercised something which is your exclusive right. For example, he has reproduced it, distributed it, performed it somewhere, has in fact infringed your copyright. So that kind of consideration is not required if you have registered your work. Apart from that, even a unregistered copyright is a copyright. Now, can artificial intelligence technologies can be protected under existing IP laws? These are the words of Francis Gehry, who's the the then president of WIPO, and he had given these words that artificial intelligence is a new digital frontier that will have a profound impact on the world, transforming the way we live and work. Now, he said these things in 2016, and in less than 10 years, we can see that his prediction has already come true. Now, there is something which is very interesting to know. There are certain technologies which we consider as disruptive technologies. These are certain things because of which the entire way in which we perform, the entire way in which we function, that get disrupted. The existing policies, the existing regulation, that get disrupted. The way we go about our daily lives, that get disrupted. Such kind of technologies are known as disruptive technologies. If I talk about disruptive technologies before AI, if I go back in time, there was printing press. For IPR, printing press's invention is considered as a huge invention. Why? Because before printing press, it was a very tedious job to copy someone else's work. The IP legislations, the copyright related issues, it skyrocketed at the time of printing press, because before printing press, you can imagine when somebody has to copy an entire manuscript manually, it is going to take hours for making even one copy. Now it was possible to make hundreds of copies in the time where you would be able to make one copy. Imagine you have to copy one book of, let's say, 500 pages. A person would have to write, and he has to write in a very legible writing. He has to be writing it beautifully because he's creating a manuscript. That's going to take a lot of time. I'm talking about the time when there was only handwritten books, handwritten manuscripts. When printing press came, it was a major revolution. It made it possible to print large number of copies in limited time. Hence, decreasing the human effort involved, hence also decreasing, mind you, a lot of employment opportunities, because you no longer require those people who are going to be writing those manuscripts. Similar thing happened when there was an advent of the internet. When there was internet, basically, just a second, in the call, I just mute it. No, yes. So before of the internet, there were a lot of things which were different. So AI, it is being at the core of next revolution after several innovations like electricity, like internet, like printing press before that. Now AI is being considered as the next core of the revolution. It is needed that we assess if present IP policies supplemented and now in the future. So several questions arise as we start to look at artificial intelligence from the perspective of intellectual property rights with respect to paternity and liability of creations, and there is need to keep up with the AI related development and shape its evolution. So variety of stakeholders will have to reflect on the correct policy mix to maximize the widest possible benefits from artificial intelligence. Now challenges in applying the traditional IP laws. Some of the problems with respect to these IP laws is that there are certain things which are uh, already a subject matter of the intellectual property, but the changes in the IP laws has not taken place as of yet. Because of that, you can see that the AI generated creation, they raise a lot of questions about authorship and ownership. For example, who should be considered the creator or owner of AI generated works? Now, let's say a AI has created a picture. The AI system, it's the developer or the user who trained it. Now, I can show you some examples of the AI, right? So, just before this lecture, I was exploring some of the generative AI tools. One of it being the Bing. Bing has its own AI tool. In the Bing image creator, which is using the AI, you can create certain kind of images for free. It is going to be using the data which is there on the internet. Now, it is having certain kind of restriction, but nonetheless, if you uh, work your way through the prompts which you're going to be using, it is going to create some very interesting results for you. So I can show you certain results which I generated just before the lecture, and we can discuss if it can be considered as IP infringement or not, right? Right, so these are certain Okay, you can see here, this is something which I've created through AI. So the prompt which I used was AI, and I said uh, Hulk in Tamil Nadu. This is what it created. This was Hulk in Taj Mahal. This is Hulk watching a match in Delhi's Kotla Stadium. This is Hulk enjoying uh, samosa in a traditional fair in India, Hulk in Mumbai. You can see now, if I take one of these images and see what are the things which it has used. Now, I did not input all the information here. I did not say that that person has to be carrying a bag in front of it, but the people who are from Mumbai or who have traveled to Mumbai would know that it is a convention in Mumbai's local train because of the kind of traffic which is there, not just in local train but in any public transport, that in order to keep their bags they need to keep it in front of them, so that when it's a huge crowd your bag does not get separated from you. Here in this picture, you can see that the AI has been able to understand. When I asked it to be in a crowded place in Mumbai, it did not just show me a railway station of Mumbai. It took me to a crowded, which looks like a crowded bus in Mumbai, and he is inside, standing there, carrying a backpack right in front of him, showing that it is using some of its intelligence as well. This is Hulk in Howrah Bridge. Here you can see him wearing a traditional dhoti, which you can associate with Bengal. This is Hulk in Charminar eating food. So I just entered food. It was also able to show me biryani, which is uh, famous in Hyderabad. This is just Hulk clicking a selfie. You can see him giving some expressions, not just creating a picture of himself. Is Hulk in some northeast. Now here it's another interesting picture which I found was quite funny. In this I had just entered Hulk in Delhi, looking like a Delhiite. So it was able to identify that a lot of boys, a lot of men in Delhi, they like to keep a beard. They would also be wearing some ripped jeans along with some cool sneakers, standing in front of a metro station. So these are certain results which I generated with the help of artificial intelligence within minutes just for this lecture. So you can see there are people. This was her in Bangalore, so he was working in a IT firm. So you can see that these are certain AI results which I was able to generate by using some simple prompts. Now these are certain things which just took me minutes. Now if you look into any of these results, for example, if I look into this one or if I look into this one or any of these images. Now let's focus upon this image. Now what you can see is here is uses it has used certain imageries. It has compiled all those images. Maybe we can't find an actual image like this on the internet, but it has used different sources. But when it is using those sources, uh, to whom this particular artificial intelligence would belong? To the person who has created this AI, that is me, the person who's in the picture, the person who has uploaded the original images which AI has used to train itself, or the person who has trained the AI itself. So there are different problems with respect to this. There can be different issues with respect to creation of artificial intelligence, and there can be different issues with respect to creation of these AI models. Now, when I talk about these issues, there are other issues also involved. For example, the traditional intellectual property laws. It may struggle to address these complexities because you may be aware that artificial intelligence is a relatively recent phenomena in terms of intellectual property rights. There were not much of intellectual property related issues before coming up of generative AI. So it leads to a lot of ambiguity and potential disputes over ownership rights. Now, some of the jurisdiction all over the world, for example, the US jurisdiction, Indian jurisdiction, they have defined authors in different forms of works. In US, they have prescribed that it has to be a human being who is an author. In India, we have not used something in specific, but as of now, we are not giving an AI any kind of ownership. But if there was no involvement of human intelligence, or the human intelligence would not have been able to generate that kind of work without the use of AI, who needs to be given the ownership of it? Now, the AI generated content, it may lack some clear attribution, making it challenging to identify the origin and responsible party for legal purposes. In case of infringement or misuse, holding AI systems or their operators accountable under traditional intellectual property laws. can be problematic due to the decentralized nature of AI development and deployment, because these AIs are not being used by the same party which has created it. ChatGPT is something which has been made in the United States of America. The person who's using it is sitting in India. He's using publishing that particular work in another part of the another part of the world. So it is very important to understand that without a proper AI regulation, that is in kind of a convention or form of a agreement between the countries, it would be very difficult to implement it. Now, the fair use and derivative works doctrine, like before getting into this, let's basically uh, simplify these things into or concerns. So, these are the two major concerns of copyright creators. This is something which I have narrowed down from whatever we had discussed in the previous slide. That is the input problem and the output problem. This is just simplification of the issues and challenges with respect to artificial intelligence with respect to copyright law. So if you divide the problems into these two heads, it will help you in understanding that these are the two major areas of problem. Every other problem with respect to intellectual property, every other issue with respect to intellectual property and copyright and artificial intelligence can be narrowed down to these two problems. First, the input problem, that is promoting artificial intelligence while protecting rights of the creators. Right now, if I tell you that that is what is being told by a lot of educators all around the world. For example, there are certain schools, certain universities which has banned ChatGPT to be used in their universities. Some people has blocked it in their respective university premises by blocking the IP addresses, by blocking uh, ChatGPT websites inside the campus, by blocking it in the Wi-Fi which is being provided by the university. Now, accessibility to the internet is no longer a problem. It is not practically possible to stop the students from using artificial intelligence. And if I tell you that you have to do a work which you would be taking like an hour or so to perform, but you know that the same kind of work, the same quality of work can be done by ChatGPT, wouldn't you feel that it is unreasonable for me to expect you to be doing it manually? It would be like asking you to calculate a huge mathematical problem where you can simply use the calculator, because there, if you when you were using your manual calculation without a calculator for your mathematics examination, you are doing it for learning math. You are not doing it to find the solution. In today's scenario, if I ask you to add like 7833 with 9466, if you do it by calculator, I'm not going to be asking you that why are you using calculator for doing this. I want this particular work manually. Similarly, if a person is using artificial intelligence without infringing upon someone else's work, without claiming it to be their own work, without infringing any of the IP laws, it is unfair to ask people to not use this artificial intelligence tools. For example, if you want to narrow down certain things for your research and you want to use AI for that purpose, that should not be seen as a problem. If you want to use artificial intelligence for certain kind of algorithms, if you want to create a pie chart, it should not be a problem. It is in fact enhancing your work. But if you're simply using ChatGPT to just generate a project for yourself, to generate an assignment for yourself, you're not using it, and as a result of which you're just simply copying it, that might be unfair. So we should not be banning artificial intelligence. We should not be stopping people from using artificial intelligence. We need to promote artificial intelligence, in fact, but while protecting the rights of the creators. Now, this is something which I talked, which a lot of students might like to listen to. That okay, he's promoting that ChatGPT should be allowed in making of your assignments of your projects. But there is another problem. Would you like that cheating was made copying was made legal in a university. Now, this is a question uh, which can be basically be answered only when there are certain things, certain kind of there are certain kind of inputs which are attached with it. For example, if there is chat gpt which is being used for creation of a certain kind of subject matter, for which it has used certain kind of instruction which has been given by you, but it is working on the models which have been given by the creators. The second question which is there as a part of the input problem is that whose work are engines that fuels these AI models. If AI model is doing upon certain things, it's not just the input which has been given by the creator or on which the AI is depending upon. For example, there used to be certain kind of initial robots which came. For example, Sophia was a robot which came. It was able to answer to the things which the even the creators of the robot had not intended. That was able to answer even things which was not feeded into its system. Not magically. It's not that the creators had not expected it to answer. That was shown in the media as if it was able to answer something which which was for answer for which never existed, or the creators themselves did not know. They had just created a small toy and the toy started to speak answers out of nowhere. It was not that. The basic issue which was there with Sophia, that particular robot, was that it was able to identify certain problems. It was able to solve those problems, and on basis of that problem solving skill it was able to answer something that. Now here, that engine, that particular robot, or any artificial intelligence for that matter, is using a large set of data which is there. And at present, because there is no regulation, that is the major problem. That is the major input problem, that you have not defined properly that what is the input data which can be accessed by these AI models without any kind of IP infringement. For example, even if that AI model, that generative AI, is using things which are there in public domain, which does not belong to a particular creator, there has to be certain things which we call as the paternity question in copyright. So even if you are using certain copyright, which is now in public domain, because you are aware that all the IPs are for limited period of time. So let's say this time period of the death of author and 60 years has expired, and that particular thing is already in public domain, or it belongs to the Creative Commons, and because of that, that particular copyrightable thing is now in public domain, and then the AI is using it. But where is the credit which has been given? Why are you not creating that particular work? That is because that is there in copyright. You can't use even the things which are there now in public domain, or you cannot use certain things which are considered as exception to infringement of copyright, because it is belong to the fair use doctrine. For example, for educational purposes, I cannot use something which is there on the media without, or which is there on the internet, without creating it properly. Like you saw that when I use those images which I had created by Bing, I had specifically mentioned that I have created it using the Bing image creator. If I had not created that particular thing, even if it is something which is freely available, even if it is something which is there in public domain, even if it is for the educational purposes, that can be considered as a IP infringement, which these AI models, they do not understand. I'm not saying the creators do not understand. I'm not saying that the creators are not aware of it, but this is a gray area in these AI models, that it is not able to, at some point of time, it is not able to identify the source, because the result which it is giving is directly not lifted from there. For example, if the AI would have been directly taking those answers from specific sources and would have been compiling those sources and giving it to you as it is, it would be like a project which you have made by copying from different files which are available on the internet. Then the Turnitin, for example, is able to identify, okay, these are the sources which you have used. What this AI is doing is that it is now reading all those PDFs, giving you a new answer which is not directly that related to that source, or directly not lifted from the source, but it has basically transformed that particular source into something new, which even the creator of that particular work may not be able to identify at some point of time. But it has used those models, it has used that data. If it has used it, why it is not crediting the owner of that particular data? If it is not creating the owner of that data, is it not morally wrong? Because you're using someone's work, you are deriving your work of that, but you're still not creating that particular work. Third problem is, who is competing with AI generated work in the market? Now, this is a question which is raised by a lot of people who think that AI is taking up their places. The problem is that it is taking their places and it is doing even better in some of the respects. No doubt there are a lot of things which AI cannot do, but that is a statement which is factually incorrect. There are a lot of things which AI is not doing right at the moment. Why it is not doing at the moment is a different area of concern, because it is a lot of things which are in gray area. There are a lot of regulations which are still not in picture, and the creators of the AI, they do not want to unleash all their work all of a sudden. But the AI related research is growing so much, and you can see it in the table also. Basically, AI related patents have increased since 2017 by 5 to 10 times. Since 2017, there were around like 8,000 patents, but it has grown to a million now or more since all these times, and that too only if we consider three majority of jurisdictions of patent, that is US, India, and China. There are thousands of patents which have been filed solely related to artificial intelligence in these years. The second side of the problem is the output problem. So you see, the input problem which I'm referring to is with respect to the input which you're providing to these AI models. The output problem is the problem which is the output, the final output of this particular model. So the first problem is with respect to identifying who's the owner. Like I discussed in this slide, who should be considered the creator, the owner of AI generated work, the AI system, its developer, or the user who trained it, right? If we are giving the ownership to any one of these people, for example, let's say if you're giving the ownership to the creator of the AI, he's the creator of the AI. You don't know who has used that AI to create what kind of work. Can you imagine a person hacking another system using their MacBook? Can you say that the owners of Apple, or the owners of the company which has created whatever laptop they have used, the owners of Microsoft, should be held as liable for that hacking? No. Similarly, you cannot say that anybody who has used that AI tool, the creator of that AI tool, should be held as liable. So if you give ownership to any one of these people, obviously they would be happy to own that particular thing, if you think it only from the benefit perspective. But they will themselves hesitate when you would be associating that ownership along with the liability, and that is the biggest concern with respect to intellectual property rights and artificial intelligence, not just with respect to copyright but overall. So artificial intelligence is something which has created a lot of issues with respect to this liability, and that is something which has to be seen, right? So now coming back to this particular slide which we are talking about. So I have discussed this particular first concern, AI generated creation. It raises question about authorship and ownership, and then AI generated content may lack clear attribution, making it challenging to identify the origin or responsible party for legal purposes. Now, there are other concerns also. For example, traditional IP laws may struggle to address these complexities, leading to ambiguity and potential disputes over ownership rights. A lot of you must be aware that EU has passed the AI Act the last year. The problem with EU AI Act is that it is going to be implemented in the 2025, and there are a lot of areas which it has not really made any kind of regulations as of yet. It has just defined a lot of things which were previously not defined. A lot of countries are going to be making their laws even within EU before it is going to be implemented in the year 2025. There are going to be still a lot of changes, and that is why when you go to the internet and try to read about the EU's AI Act, and you read that particular structure, it is just something which is defining certain things. It is yet to crystallize into something which can actually be applied, because there are a lot of ambiguities, there are a lot of potential disputes with respect to the ownership rights. And even if you assign those ownership rights, there are still a lot of answers which are to be given with respect to the liability question, which I pointed out with respect to the thing with respect to the output problem. Now, in case of infringement or misuse, holding AI systems or their operators accountable under traditional IP laws can be problematic due to the decentralized nature of AI development and deployment. Now, the present IP laws, obviously they are struggling, not with just with respect to the fair use doctrine, but also with respect to the problems related to the definition of the works. The present definitions, let's say for example of ownership, it does not take into account AI. And even the different jurisdictions, that is the different courts of a different part of the world, they even when they have attempted to answer this question, they have not really been able to answer it to the satisfaction of the AI related scholars. For example, US gave a judgment in 2022 where it the USPTO, the patent office, had given a certain kind of ownership of a work to an AI, but they took back their own words afterwards by saying that there was some kind of error in the application procedure, so they wanted to trace it back. There has been certain kind of problems, but the use of AI has increased. There are some recent examples. For example, Microsoft, GitHub, OpenAI, a lawsuit accuses these companies of violation of copyright law by allowing Copilot, a code generating AI system which is trained on billions of lines of public code, to regurgitate licensed code snippets without providing proper credit. And that is why you see in ChatGPT there are a lot of things which goes uncredited. AI art tools are there, companies behind uh, popular AI tools like Midjourney, Stability AI, which are facing a class action lawsuit. The same kind of AI which I used to show you those images of Hulk in India. There are certain kind of infringement. For example, Hulk, if you are aware, he is a intellectual property right which is owned by Marvel. So nobody can actually use the actual kind of the merchandise without their permission, but they're still able to generate that, and it is something which can become problematic. Getty Images versus Stability AI, it was initiated legal action. Getty Images, you might be aware, it is largest platform for public images. Some it is providing for free, some is not freely available in public domain, and it has initiated legal action against WTI for using millions of its images for the training purposes of art generating AI, which it had used without providing for any kind of proper AI. So I think I've covered the issue largely, and I hope that you are able to understand the gist of the problems which are associated with artificial intelligence and the copyright. I'd be happy to take up the questions from the audiences. I have received a text from Hiteshi that there are some questions. I think we can now start with the Q&A session.
Okay, so the question we have with us is, what are your views with reference to deep fakes and copyright infringement?
Right. So good question, and it is something which is going to be of a concern for us, and that is something because deepfake is something which is a modified version or the AI version of what used to be an offense already. That is a offense of morphing. When you're morphing a particular picture into something, that was already a problematic area which was there. With respect to deepfake, it is not just a intersection of these two laws that is related to AI and copyright, but it is a issue which is related with AI, copyright, and criminal law. So when you're talking about deepfake, you're using and plus also the fourth area is the privacy law, data privacy. So it is a huge intersection. It is AI, IP, data privacy, and criminal law. So you're going to be using all these laws, and that is why when you see there are a lot of problems which are associated with intellectual property rights, which are left unanswered when it comes to these modern ways of committing crimes. So if you want to make a law, and that is something which has to be done, and that is something which is related to the criminal use of artificial intelligence, so we need to have certain laws related to it. And there, when there would be a law of artificial intelligence which would be coming, it is not going to be changing just intellectual property rights law. It is going to have an impact on different laws, and it will have to accommodate it by changing and modifying every other law by some kind of amendment. I can give you one example. For example, when the Information Technology Act came, if you read the Information Technology Act 2000, you would see that there were amendments made not just in the IT sphere, but it brought along the amendments also in the field of there were amendments which were made in Bankers Book, there were amendments made in the RBI Act, there were amendments which were made in the Evidence Act. So such kind of amendments will have to be made. As of now, when it comes to the present legislations, we are finding it hard to identify a particular specific regulation. But the present IP regulation, the present IT regulation, and the present criminal law litigation is being used in order to criminalize those deepfakes. I hope I have answered to your question. Second question is, as you said, it is a huge problem to find the correct culprit in case of AI generated infringement. Who should be held liable in your opinion? So, in my opinion, like you stated, because we do lack a resolution with respect to this, and what is the solution according to you for the jurisdictional problem that occur in AI contained IP infringement? So, these are two separate sub questions. So, the first question which you asked was with respect to finding it hard to find the correct culprit, right? So, in case of AI generated infringement, who should be held liable? If it is a AI generated infringement, you'll have to go to the basic principles of the criminal laws to be forming any kind of regulation with respect to this. That is the person who had both the mens rea and the actus rea. You can't be using blaming the tool for the creation of it, as a result of which you need to identify the person who had used those AI tools. For example, if it is a deep fake, you can't be blaming the person who has created that tool for deepfake, the creator of the deepfake. You have to basically find out who's the person who has used those deepfake. Now, what is the role of the makers of the deepfake in it? That they have to perform what we call as the roles of intermediaries in the ambit of Information Technology Act. If you have read Information Technology Act, there are certain rules and regulations with respect to the intermediaries. So deepfake will have its responsibility within that particular framework. We'll have to understand what was the role of deepfake, the creator of that deepfake. That is to provide for the information as to who used deepfake to create such kind of content. But the criminal liability about it would lie upon the person who had used it. So with respect to the finding of the real culprit, it would for sure it's going to be the person who has done that work. The question with respect to AI generation of IP is that that is something which I'm going to be coming as a solution for it, along with the second question which has been asked in the relation with it. So I'd answer the solution for that one and the solution for this one together. So this question is, what is the solution according to you for the jurisdictional problem that occur in AI contained IP infringement? See, the IP infringement with respect to the AI, the jurisdictional problems, this is something which has again been answered by the present IT enactments, and there are certain issues which are there in practicality. But this is basically, it has to be seen where that particular AI was used, and at what point of time it was used. So there are certain tools, for example, VPNs, the virtual proxy networks, etc., which are being used, and it is creating a lot of problems to the law enforcement agencies. But it has to be seen at what point of time that particular AI related tool was used and where it was used. So accordingly, it will have to be given answer of jurisdiction. But with respect to the solution lies for the previous question as well as this question in creating of a specific regulatory framework. If you read the discussions which are going on, there are a lot of discussions which are going on at the level of the policy framework makers. For example, there are makers of AI who have discussed about giving an answer to this question at domestic level. That is at the level of India. There are IP and AI related documents which are released by our Indian government as well as there are discussion by WIPO as well as WIPO's discussion upon artificial intelligence. The answer which has been given by both these entities, that is the Indian entity and the international entity, that is WIPO, that is World Intellectual Property Organization, is that we need to create a regulatory framework. So we have reached a level when it comes to the answering of this question of AI, where we have narrowed down that these are the problems. Earlier, we were facing such kind of problem because, like in my talk, I told you that it is a disruptive technology. It is something which has changed our perspective towards how we actually live. There are a lot of things which has changed. Now, AI is not just in healthcare, in the automotive section. It is also creating new seeds. It is now even creating new kind of beings. New microsomes are being created. New biological things are being created. So these are certain problems which we are facing. That there are certain creations which we are not able to even manage. That how to stop them. So as a result of which, the first step was identification of problem. At a world stage, we have been able to identify that this is the problem. The solution which has been identified as of yet is that we need a regulatory framework. Now, with respect to this regulatory framework, as of now, there are no effective regulations, I would say. There is a EU AI Act, which is a generic act. It has not addressed to some very specific problems. Nonetheless, at least it is a first step towards making of a regulation. So the solution to both the questions which you have asked is to make a regulatory framework and decide at a regulatory level that who's going to be responsible, what is to be going to be what is going to be the role of the AI creators, just like we created roles for the intermediaries of these IP resolution. To give you a little bit more input about what is the role of intermediaries, intermediaries are those intermediaries which are creating that platform in social media. So Facebook is an intermediary, YouTube is an intermediary. They have certain roles which they can play. They cannot abstain altogether that we don't know who's uploading these contents. They'll have to take their measures. They are also answerable to the government to a certain extent as per the regulations by the government. So those are the rules of intermediaries. We don't call these AI creators and intermediaries, but we need to give them a particular name. We need to create regulations where we are deciding upon their roles and responsibilities. If they're performing their roles and responsibilities and they're helping us to identify that what are the inputs and what is the output of their AI model, that is going to clarify a lot of things, and it is going to help us in identifying the real culprits. As of now, because of lack of any kind of proper regulation, this is lacking. So the major solution in short is to create a regulation. Are there any more questions?
No, sir. Now we would like to conclude today's lecture. I would like to extend our heartfelt gratitude to Mr. Ankit Shrivastava for sharing his deep knowledge and insights with us today. Your expertise and clarity have been truly invaluable. A special thank you to the organizing team whose efforts behind the scenes made this lecture possible and seamless. Once again, thank you all for joining us, and we look forward to seeing you at our future events.
Thank you so much, Tashi, and the organizing committee. I mean, the questions which you asked were, which shows that you were deeply interested in the topic, and hopefully we'll have to get a deeper understanding of it if we get an opportunity in the lecture series, where we can dwell to the questions even with even more nuances. We can discuss more about what are the issues and what can be the proper solution. This was just a basic idea with respect to what are the present challenges in this particular area of artificial intelligence and copyright. So thank you so much, and hope to see you again.
Thank you, sir.